Okay, we'll start in a minute. So is everyone excited that Christmas is so near? It's just in about 4 days.
No.
No.
Finish, be over with.
Yeah.
Manjo, can I ask a question before you get into it so that we don't take up too much time in the lecture?
Is that you, Leonie?
Yeah, it is. Sorry.
Yeah.
I've got a question about your assignment of cases. I noticed today that a case that, I've got to get this right, a case that I have chosen and that you assigned to Monique Tudman, sorry, covers the same issue. Is that a problem?
No.
Okay.
No.
I just thought that they had to be spread out over the weeks, that was all. We seem to have, like, a couple of the cases seem to touch on the same issue.
You're actually part of the same team, right? You're in the same
Yes,
group.
we are part of the same team.
And the case that was assigned to Monique touches on the same issue that you chose. Is that what you're saying?
Yeah, that's what I'm saying, yeah.
Yeah, that's not a problem, because the important thing is, as far as the cases that I assigned, I simply assigned them simply because no one else took them. And so the goal was to make sure that we cover all the cases that are in the list of key cases.
Yep.
And I simply disregarded whether or not, as far as the group is concerned, it may actually be on a topic that has already been covered in one of the cases. So I disregarded that. Otherwise, it was going to be very complicated if I had to factor that in as far as the random assignment that I did on the cases.
Okay, no worries. I just wanted to double check, that was all.
Okay, so we could probably begin. So welcome everyone to week 6, and we're obviously halfway through the end of the term, and then we're off to a short Christmas break starting next week. And well, I think that for a lot of people, this is one time where they're beginning to feel like, a bit more relaxed, not really focused on getting things done. But that's probably good because it's obviously Christmas. So let me start this tutorial by wishing everyone an advanced Merry Christmas. And so tonight, as we've always done, you don't know me at all. What's that from, Jess? I'm not sure what that means, Jess. Oh, you're far from relaxed. Okay. Oh, so this is probably a good topic, laughing towards happiness. Jess? So I think this is going to be a good topic for you, laughing towards happiness. If you feel like you're not relaxed, I think after this short session, you should be. I'm hoping you should be. Okay, so we're going to spend the first 10 minutes dealing with a topic on happiness for learning. And for this session, we're going to be talking about laughing towards happiness. Again, our view was that I seem to have missed a slide. I don't know where it went. Okay. I wonder so I had a slide here that's missing. So we will recall that at our first session, we talked about, so we're just going to do a quick recap. In the first session, we talked about the importance of happiness, mainly because I think everyone wants to be happy. It's difficult to conceive of anyone who doesn't want to be happy. And oftentimes, we might say that when people want to be successful, perhaps in their career, perhaps, have a successful relationship, the reason is because they think that these lead towards happiness. And I had suggested at the first Happiness for Learning mini workshop that it's not so much about being successful so that you can be happy. It's actually quite the reverse. Based on studies, you should actually be happy in order to be successful. And the reason for that is that studies show, and you probably know a lot of people who seem to be successful in terms of their careers. They probably have plenty of money, maybe, and yet they seem to be unhappy. And yet we encounter people who might be considered to be less successful, perhaps not even successful at all by societal standards, and yet they seem to be happy and contented. And as we said in the first session, when we speak of happiness, we're looking at the concept of happiness from a very broad viewpoint. So it can be about joy, it can be about a sense of amusement, it could be about a sense of positivity, following the definition that is propounded by Professor Carol Dweck and Barbara Fredrickson on what comprises positivity and what comprises happiness. So that was the first thing we did. And I think in the second session, we talked about the importance of paying attention to what makes you happy. And again, that is a crucial point, because oftentimes, we come across something that makes us happy, but then after a while, the value of that thing that made us happy wanes, it disappears. It could be that, you have a promotion, you got a grade of high distinction in your unit, you encountered who you thought was the love of your life, and after a while, reality sets in, and this doesn't seem to be the Prince Charming, and this, what is that? So if it's not Prince Charming, it's somebody else, and then you begin to be unhappy. And what research tells us is that we need to refocus, we need to pay attention on things, because things that made us happy before, through time, because of adaptation, we forget about them. But if we refocus our attention on those things, we then begin to appreciate the good things about our partner, or about our jobs, or about our grades. Then we begin to be happy. So that was the second point, the need to pay attention. That's why the term there is pay. You're actually paying for it. You're paying it with your attention. Now, the third thing we talked about at the last session was about the need for journaling, and the idea being that we're in a better position to understand our thought processes. We're in a better position to analyze what makes us sad, or even analyze what makes us happy, but actually doing a process known as journaling, and putting our thoughts on paper. Because assuming you were confronted with a problem, assuming you were trying to find ways and figure out whether or not you're happy, it's difficult if they're just all in your head. But once you put them on paper, you can actually keep on going back to them. One, as a way of paying attention to what makes you happy, but in another sense, the idea of putting things on paper enables you to actually, analyze things, and make you, put you in a better position to figure out, whether or not you should be happy about this or not, and if you're not, what should you do? And so the fourth, at this session, we will talk about, there are 10 of you. We're going to talk about the value of laughing towards happiness. One of the key research that has been identified is that even the act of trying to put a pencil or a pen in between your lips, so that it kind of resembles an act of smiling, actually triggers some certain physiological changes in your body. So much so that when people, and this is based on experiments, okay? I'm sharing the experiments with you. So much so that the experiments indicated that people who were made to kind of mimic that smiley face, even if they were not really happy, actually ended up feeling better, feeling more positive. On the other hand, people who were forced to watch, for example, a video that made them sad, ended up being unhappy, even if they were on their own. They were actually happy in their own lives, but the fact alone that they were exposed to something that made them sad had an effect on them negatively. And it is crucial, therefore, to remember the importance of happiness, not so much just because we all want to be happy, but because according to studies of Barbara Fredrickson, and according to what is now known as the broaden theory, or build and broaden theory, when a person is actually happy, that person is able to see bigger things. The person is able to see a wider picture. That person is able to see a wider perspective of things, as opposed to somebody who is unhappy. The focus is so narrow, that person begins to fail to appreciate the good things that are happening and ignore crucial information. And so the research of Barbara Fredrickson, who is a foremost authority on happiness, suggests that there is a very important role in happiness, mainly because it allows us to grow and allows us to see the bigger picture, so that we're able to see, perhaps we might say, you know, life in its full glory, instead of focusing on the minute moments of our lives that make us quite sad or unhappy. So having said that, what I'm going to do now is to, I'm going to invite you to watch a video. And because, you know, at some point we want to be experts, right? You want to be lawyers, you need to be an expert in the law. And especially for Jess, I dedicate this video to Jess. And this is a video, I think, which you might enjoy, because this is a video of an expert. Okay, so let's see. So, you know, the important thing is we can't be too serious about a lot of things, okay? So let's take a moment to just have a break. This is 7 minutes.
Along today,
okay.
Our company has a new strategic initiative to increase market penetration, maximize brand loyalty, and enhance intangible assets. In pursuit of these objectives, we've started a new project for which we require 7 red lines. I understand your company can help us in this matter.
Of course. Walter here will be the project manager. Walter, we can do this, can't we? Yes, of course. Anderson here is our expert in all matters related to the drawing of red lines. We've brought him along today to share his professional opinion.
Nice to meet you. Well, you all know me. This is Justine, our company's design specialist. Hello. We need you to draw 7 red lines, all of them strictly perpendicular, some with green ink and some with transparent. Can you do that?
No, I'm afraid... Let's not rush into any hasty answers, Anderson. The task has been set and needs to be carried out. At the end of the day, you are an expert. The term red line implies the color of the line to be red. To draw a red line with green ink is, well, if it's not exactly impossible, it's pretty close to being impossible. What does that even mean? Impossible? I mean, it is possible. There are some people, say, suffering from color blindness, for whom the color of the lines doesn't really make a difference. But I'm quite sure that the target audience of your project doesn't consist solely of such people.
So in principle, this is possible.
I'll simplify. A line as such can be drawn with absolutely any ink, but if you want to get a red line, you need to use red ink. What if we draw them with blue ink? It still won't work. If you use blue ink, you'll get blue lines. And what exactly did you mean when you talked about the transparent ink?
How to explain? I'm sure you know what transparent means.
Yes, I do.
And what a red line means. I hope I don't need to explain to you.
Of course not.
But you need to draw a red line with transparent ink.
Could you describe what you imagine the end result would look like?
Oh, come on, Anderson. What have we got here? Kindergarten.
No, I'm just trying to
Let's not waste our time with these unproductive quarrels. The task has been set. The task is plain and clear. Now, if you have any specific questions, then go ahead.
You're the expert here. All right. Let's leave aside the color for the moment. You had something there also relating to perpendicularity.
7 lines, all strictly perpendicular.
To what?
To everything amongst themselves. I assumed you know what perpendicular lines are like.
Of course he does. He's an expert. 2 lines can be perpendicular. All 7 can be simultaneously perpendicular to each other. I'll show you. This is a line, right?
Yes.
And another, is it perpendicular to the first line?
Well,
yes, it is perpendicular.
exactly.
Wait, I'm not done. And a third one, is it perpendicular to the first line? Yes, it is. But it doesn't cross the second line. They're both parallel, not perpendicular.
Oh, suppose so.
There it is. 2 lines can be perpendicular.
Can I have a pen? How about this?
This is a triangle. It's definitely not perpendicular lines. And there are 3, not 7. Why are they blue?
Indeed, I wanted to ask that myself.
I have a blue pen with me. This was just a demonstration.
That's the problem. Your lines are blue. Draw them with red ink.
It won't solve the problem.
Well, how do you know before you've tried?
Let's draw them with red ink, then let's see. I don't have a red pen with me, but I'm completely certain that with red ink, the result will still be the same.
Didn't you tell us earlier that you could only draw red lines with red ink?
In fact, yes, I've written that down here. And now you want to draw them with blue ink. Do you want us to call these red lines?
I think I understand. You're not talking about the color now, right? You're talking about that what do you call it?
Perpendicularity, yes!
That's it. Now you've confused everyone. So what exactly is stopping us from doing this?
Geometry.
Just ignore it.
We have a task. 7 red lines. It's not 20, it's just 7. Anderson, I understand you're a specialist of a narrow field. You don't see the overall picture. But surely it's not a difficult task to draw some 7 lines.
Exactly. Suggest a solution. Now, any fool can criticize. No offense. But you're an expert. You should know better. Okay. Let me draw you 2 perfectly perpendicular red lines. And I will draw the rest with transparent ink. They'll be invisible, but I'll draw them.
Would this suit us? Yes, this will suit us. Yes, but at least a couple with green ink. Oh, and I have another question, if I may. Can you draw one of the lines in the form of a kitten?
What?
In the form of a kitten? Market research tells us our users like cute animals. It would be really great if we could
No.
Why?
Look, I can of course draw you a cat. I'm no artist, but I can give it a try, but it won't be a line anymore. It'll be a cat. A line and a cat. These are 2 different things.
A kitten, not a cat, but a kitten. A little, cute, cuddly. Cats, on the other hand,
It won't make a difference. Anderson, at least hear her out. She hasn't even finished speaking and you're already saying no. I got the idea, but it's impossible to draw a line in the form of a cat. Done.
What about a bird?
So, where do we stop? What are we doing?
7 red lines, 2 with red ink, 2 with green ink, and the rest with transparent. Did I understand correctly?
Yes.
Excellent. In which case, that's everything, right?
Oh, I almost forgot. We also have our red balloon. Do you know if you could inflate it?
What do I have to do with balloons?
It's red.
Anderson, can you or can you not do this? A simple question.
As such, I can, of course, but...
Excellent. Organize a business trip. We'll cover the expenses, go over to their location, inflate the balloon. Well, this is very productive. Thank you all.
Okay. So, I don't know if that, I wonder if that was helpful to you guys, but oftentimes when I'm in need of a laugh, that's what I do. I watch videos that are funny. Okay, so before we start talking about tonight's tutorial on the topic on legislative scope and purpose, was there any question that you might want to raise, or any point that you would like to raise?
Manjo, I've got a quick question about the quiz scenario.
We're talking about the quiz right now.
We're not? Sorry?
Well, when you say quiz scenario, are you talking about a specific quiz?
Yeah, the one that's open right now. I just wanted to clarify. Have the university in the scenario applied for funding and been rejected, or have they not?
I'm trying to remember the fact. I'm not sure it really matters.
Okay, thanks.
So in relation to that particular, so I don't want to go into the legal remedies here, but there is a judicial remedy which we will cover, I think, in week 11, which is about declaration. So declaration is an action which is filed before a court for the purpose of asking a court to determine whether or not a law is actually valid or not. And it doesn't have to mean that a particular decision has actually been made that affects a particular person at that specific time, but the possibility that the application of the law might affect that person actually provides that person the legal standing to file an action for judicial review in order to question the validity of a law. And that is known as declaration. And that's the reason why I'm saying, because we're not looking at judicial remedy at this point. We're looking at that issue about the divergence or the contradiction between the enabling law as opposed to the subordinate legislation or the regulations passed by the minister, I think. So the focus should be that, as opposed to whether or not funding had actually been applied for and was then denied.
Thanks, Manjo. That's helpful.
Other questions, points? Okay, now, so we could probably begin. Before we proceed with tonight's tutorial on legislative scope and purpose, Peter Anderson sent me an email today asking if we could talk about the case notes. I'm not exactly sure how I will talk about the case notes unless some of you ask me some questions, or I could probably try whatever might not be too clear about the assessment. So he failed to tell me what it was that he wanted to ask about. Would any of you have any question about the case notes assessment, which I could try to then explain? I mean, you know what, okay, so the important thing really about the case notes assessment is that as you write it, you have to be very conscious and aware of the marking criteria and the marking rubric. So you have to make sure that as you write the case note, you're addressing the marking rubric. So for example, if you're being assessed in relation to the way that you write the facts, about the identification of the legal issue, about the discussion of the rules as well as the legal principles, and then about the importance of the case note. So you have to make sure that based on the rubric, you're writing the case note according to what is expected. So the rubric actually provides a framework, provides guidelines on how the case note is meant to be written. And so, for example, if we talk about the facts, we have to make sure that, because I think you only can devote about 150 words for the facts, you should only be writing as facts those information which are crucial towards us knowing what the legal issue really is. So the facts should lead towards a legal issue, towards a legal problem. So any fact that has nothing to do with the legal problem pertaining to the weekly topic, then it shouldn't be there. So the facts will provide us a, so in fact, if you look at there are plenty of examples about how the facts should be written in a case note. The textbook, our prescribed textbook, contains hundreds of cases. And in each of these cases, what Craig, Macmillan, and Smith have actually done was to provide the factual scenario of the case. So by going through the textbook, you have an idea already about how to write the case facts. And if you notice, when they write the case facts, it gives you a sense of what actually transpired, what the problem was among the parties or between the parties, what the law was, what the administrative decision probably was, and then why there was a question of whether or not an administrative decision or a law should be challenged either before the court or before the Administrative Appeals Tribunal. So they provide the factual scenario there. So there's so many examples of how the factual scenario is written. And as you read the factual scenario, you get a sense of what exactly is the legal problem here? What is the legal issue that needs to be identified? What is actually being confronted by the court, so that if the court addresses the legal issue properly, it will then be able to state a proper ruling that would answer the legal issue. So what is missing, for example, what would be missing mainly in the cases that are found in the prescribed textbook is that it doesn't really discuss the legal issue, not that, in the manner that we would like it written in the case notes assessment, in relation to the decision as well as the legal principles. What the prescribed textbook has done has been to actually excerpt or copy and paste some key statements in a case itself. Whereas in our case notes assessment, you are required to paraphrase the decision itself, use your own words. So that is a crucial point. You're not permitted to just copy and paste or excerpt passages in the case. You need to be able to use your own words, especially because we have a word limit. And having done that, I'm not sure there was a conclusion as well. Probably not. But one of the other sections of the case note assessment, which is not always found in case notes, is really the need for you to discuss the importance of the case. Why is that particular case important to administrative law? So it forces you to reflect on the value of the case. Why do we need to even study that case? Why is it important? In doing so, you shouldn't be repeating what is in the discussion concerning the legal principles. You shouldn't be talking about the legal principles again. Your goal is to say, why does a knowledge of the legal principles matter? Why is it important for us to know these particular legal principles as far as administrative law is concerned? Okay, so I guess that's as much as I could say, unless you want to ask specific questions. None? Okay. So we could probably proceed. So tonight we're going to be talking about legislative scope and purpose. This is the topic, isn't it? I'm getting confused. Okay, yeah. So this is the topic, and the concept of legislative scope and purpose is important because, in many cases, when an administrative decision maker makes a decision, oftentimes the decision made by the decision maker is actually based on a statute or a law that has been passed by the parliament, whether the state or the commonwealth, for example. And oftentimes, when we look at a law, for example, a law can indicate what its aims might be, meaning its purpose. The problem sometimes is that, as far as the law is concerned, it can have multiple purposes, or what has been defined or understood as polycentric, a polycentric law, a law that tries to consider a lot of purposes. It could be about, so if you look at the Freedom of Information Act, on the one hand, its goal is to ensure that people have access to information. But on the other hand, it talks about the need for privacy, the need to protect state secrets. So when a person, for example, seeks to obtain information or a document that's in the possession of a government official, should it be released in order to uphold the goal of the Freedom of Information Act, which is for the public to know about documents, or should it be weighed against the interest that in releasing the document, it may create problems for the government, in the sense that it can lead to breaches of national security, or it can lead to questions about confidentiality and so on. So that's an example of polycentricity. So that's one of the problems there. Two, it might be that as far as the administrative decision maker is concerned, it might be that the law is very specific on what the administrative maker should be doing, what criteria it should be applying, what factors it should be considering. And if a decision maker, for example, fails to follow the requirements of the law, then the question arises whether the failure to strictly comply with the requirements of the law, would it mean that the decision of the administrative decision maker can then be vitiated, and that it can then be invalidated and questioned before a court? So these are some of the questions that we need to examine. And as important, we now realize that as far as the Administrative Decisions Judicial Review Act of 1977 Commonwealth is concerned, the failure of a decision maker, for example, to consider relevant considerations when they are required to be considered by the law, or to consider irrelevant considerations when they shouldn't be, are actually grounds for judicial review. And so that's important. Now, I would like to flag your attention, and we're going to be going through this in a short while. I would like to flag your attention in the sense that if we will recall, judicial review is meant to look at the legality of administrative decisions. It tries to veer away from examining the merits of an administrative decision, because merits review belongs to, the Administrative Appeals Tribunal if that remedy were available. And given the supervisory role of the courts, their job is not actually to examine the factual correctness of decisions of administrative decision makers. And yet, when we examine these ideas of the courts trying to determine whether or not the decision maker considered relevant considerations or considered irrelevant considerations, it would appear that actually it seems to be looking into the merits of the decision itself. So I'm just highlighting that because we're going to look into that in a short while. So tonight, in terms of objectives, after studying this topic, you should be able to discuss and explain the 3 key rules that a decision maker must observe in making a decision or in exercising a statutory power, namely that a decision maker must exercise a statutory power according to the purpose for which it was conferred. In exercising a statutory power, a decision maker must not take into account irrelevant considerations. And if it did, what actually happens? And in exercising a statutory power, a decision maker must take relevant matters into account. And that also raises the question, would the decision maker actually be required to take account of every single factor that needs to be considered? So in other words, if the law says that there are 20 factors that should be considered in arriving at a decision, would the failure of the decision maker, for example, to allude or to direct its attention to those 20 factors in its decision be a ground to question the validity of the administrative decision? So can you see the point there of why it might be important? Or what if the decision maker relies on a summary prepared by an assistant? Would that be sufficient for the purpose of the decision maker complying with the requirement that he must take relevant matters into account? Now, obviously, I'm just raising these points because we don't have enough time to actually cover all those points, given the the limited time. You could ask those questions in the course of the tutorial, and hopefully the discussion questions that I have will allow us to dig deeper into these legal concepts that I have highlighted. So, before we proceed and continue, would you happen to have any questions? Questions? Okay, so there is a question here from Ilonka. So just to confirm, these 3 key rules will only be considered once it was established that the decision was made under an enactment and the statute allows for review. The answer is no, and I will explain. So let me repeat the question because this is a very, very, very good question from is that Ilonka or Ilonka? Can I just get a clarification? I don't want to mispronounce your name.
Ilonka.
Ilonka. Okay, I don't want to mispronounce your name.
That's all good.
I don't want people mispronouncing my name, which is actually Manjo. Okay, so the reason why I say that these 3 key rules, so let's go back to that, that these 3 key rules are not limited to the statute is because we will remember that as far as the ADJR Act is concerned, it was actually formulated or codified in 1977. But prior to that, the courts in the common law jurisdiction have already made findings that where an irrelevant consideration, for example, was made by a decision maker in arriving at a decision, then that irrelevant consideration can actually invalidate the decision. So for example, if you remember the case of the Wensbury case, which I think we covered, or we will cover in the future. Say the question is, should children who are 6 years old be permitted to go to a movie house on a Sunday, even with a grown-up? So let's assume that that's the factual scenario. And the decision maker then, instead of just looking at that question, considered questions such as whether or not the child had red hair in arriving at a decision. That would be an example of an irrelevant consideration, which in the case of the Westbury Corporation, the court said that it would be unreasonable for a decision maker to consider irrelevant considerations in arriving at a decision, so that somebody making a decision on the basis of the fact that a person has red hair, or that perhaps a person might be gay, for example, putting it to an extreme, would be irrelevant considerations that would invalidate a decision. So for example, I think in the US military, and I think in Australia, there have been instances when persons were not promoted or were not given a commission because they were gay. I have nothing against gays, because in fact I'm very supportive of it, of the idea of gay. So let me be clear about that. I'm just using that as an example. But prior to that huge debate in Australia, there were already questions about should somebody who is gay be allowed to be in the military, or for that matter, should women be allowed to join combat forces in the front lines? Correct? And so in those cases, there have been decisions which said that to consider the sexuality of a person seems to be an irrelevant consideration. So in other words, even in the absence of an enactment, because certainly you must remember that administrative decision makers don't make decisions solely on the basis of a statute. They can make a decision on the basis of their powers under the Constitution. They can make their decisions on the basis of what is known as the discretionary or prerogative powers of the executive, which are the inherent powers of the executive, even in the absence of a constitution, such as in the UK or New Zealand, or even in the absence of an enabling law coming from the Commonwealth Parliament. So that's another source of executive power. And so in those instances, as we've said, decisions are often made by a decision maker. And if a decision maker makes a decision on the basis of what is known to be an irrelevant consideration, then the courts will strike down the validity of that decision. Okay, now, having said that, the only reason why, as far as the way that the objectives for tonight's tutorial were stated, that we're looking at in the exercise of a statutory power, we're doing this simply because we're trying to direct our attention to the fact that under the ADGR Act of 1977 Commonwealth, when a decision maker takes into account irrelevant considerations or fails to take into account relevant considerations when they should be, that is a ground for judicial review as far as the ADGR Act is concerned. So we're just focusing our attention there. But what we need to recall that it is permissible to have judicial review not on the basis of the ADGR Act, but for example, on the basis of Section 75(5) of the Australian Commonwealth Constitution, or Section 39B of the Judiciary Act of 1903. Okay, so that's the only reason why we're doing this, because as we said, I think I pointed out 2 tutorials ago, because somebody asked the question. So when you're confronted with a factual scenario and you're trying to provide legal advice, should you go through the questions of ADGR Act, the Constitution, the common law, Section 39B of the Judiciary Act? And my answer was, generally, when a lawyer would prepare an application, for example, for judicial review, he would be very conscious of the various ways by which he can cite the legal basis for an application for judicial review. But if it is very clear that the administrative decision can actually be the subject for an application of judicial review on the basis of the ADGR Act of 1977 Commonwealth, then focus on that. And in fact, as far as the final examination is concerned, if you're able to provide an answer or provide a legal advice on the basis solely of the ADGR Act of 1977, then end there. You don't have to go through a discussion of Section 75(5) of the Constitution or Section 39B of the Judiciary Act of 1903 Commonwealth. So from Ilongka here, so this will be the courts, not at the AAT. Okay, so but let me just go back to one other point before I respond to that, Ilongka. Let me just respond to another point you said here, because what you had said was that, just to confirm, wait, am I speaking too fast? Or it's okay? Is the pace okay? Or okay. So I got Ilongka, to give me the thumbs up. Very good. So, oh, too fast. Okay, I'll try to slow down. Okay. So let me just repeat. Oh, you can't keep up. Yeah. So let me just go back. So if you can't keep up, try to go back to the recording at some point. So apologies. I don't know when I should be slowing down. And okay. So I want to just go back. I want to address myself to what has Ilongka's pointed out, which I said was important. I want to clarify something here, because your point was, just to confirm, these three key rules will only be considered once it was established that the decision was made under an enactment, and the answer was no. Okay, because as I said, an executive decision maker can make a decision on the basis of the Constitution or prerogative powers. So I said no, but we're focusing on this statutory power because of the ADGR Act of 1977 Common Law. Now, she also said that the statute allows for review. I want to address that because there seems to be a confusion there. We need to remember that in regards to whether or not judicial review is available under the ADGR Act of 1977 Commonwealth, what is crucial is that the decision is an administrative decision. And we also need to know that the decision was made under an enactment. I mean, of course, you talk about legal standing. You talk about whether or not there's a ground for judicial review. You also talk about whether or not it is non-justiciable. But focusing our attention on the two crucial points about judicial review under the ADGR Act, the two key requirements would be that it is an administrative decision, and secondly, that the decision was made under an enactment. There is no requirement that the statute itself or that the enactment allows for judicial review. Are we clear? Now, I see that there is a confusion because in relation to the Administrative Appeals Tribunal's jurisdiction, in relation to applications for merits review, which was actually one of the answers in quiz 4, I think, we need to remember that the Administrative Appeals Tribunal will only have jurisdiction over an application for merits review. One, if the administrative decision is made under an enactment, and secondly, the enactment itself also provides that an application for review is available with the AAT. So those are the two twin requirements. So for there to be for the merits review to be available with the AAT, the administrative decision must be made based on an enactment, and the enactment itself must provide that review by the AAT is available. On the other hand, as far as the ADGR, as far as the judicial review is concerned, the only requirement there is that the decision is made under an enactment, period. There's no requirement that the enactment itself must provide for judicial review. Are we clear about that? So I just wanted to clarify that. Okay? Questions so far before we continue? Was that clear? Clear or not clear?
Manjo.
Yes. Who's that?
It's Jesse here.
Jesse, yes.
You mentioned just something a little earlier about when a decision's made under the ADJR Act, that you still work through jurisdiction, standing, and so forth. But if there was a decision made under an enactment and a person is aggrieved by that decision, don't they already have standing for a judicial review? Isn't there already jurisdiction? Do we need to talk about that when answering a problem question? Do we need to talk about justiciability since it's already a decision made under the a decision made under an enactment?
Oh, okay. I see what you mean. Okay. Let me just clarify a point there, because I think there was a point there which I think needs to be clarified. Jesse, you had said that the decision was made under the ADGR Act. Okay, I think you may have misstated that. So the decision is made under an enactment. And I think your question then was, if a decision was made under an enactment, the question was, does it then assume that that person has legal standing? Correct? That was your question. Is that correct?
Yes. Do you need to go through those 5 elements: legal standing, jurisdiction, and the others?
Very good question. Now, so we will recall, as a matter of just a brief review, that there are 5 things that need to be shown before we know that judicial review is available. One is that the person has legal standing, and I'll go back, and this will address Justice's point, very important point. The person has legal standing. 2, that there is an administrative decision. 3, that there is a ground for judicial review. 4th, that it's a justiciable question. 5th, that there is identified a proper judicial remedy. So those are the 5 things. And of course, I think, did they say ground for judicial review? Now, so let's go back to that question about legal standing. The reason why you need to be able to oftentimes, unless it's very obvious, the reason why you need to oftentimes indicate whether or not legal standing should be discussed is because in many administrative decisions, the one who's filing an application for judicial review might actually not have legal standing. So we have plenty of examples in the case. So for example, when a decision was made to prohibit the use of certain anti-abortion pills in Australia, okay, so there was a decision made by the executive, I think the Minister of Health. There was an organization that sought to challenge the legality of that decision. So I make that point that sometimes an administrative decision impacts a lot of people. So the question is, does that organization have the right to challenge the legality of the administrative decision? It can also be that from Grant, yes, but he explained it too fast. Grant, sorry, can you clarify that? Was this in relation to something I said? Okay, we can just come back to that. Or we will sometimes notice that, for example, in the case of Becco Wolson versus the Minister for Aboriginal Affairs, there was a decision that related to whether or not mining could be permitted in certain areas that potentially had an impact on Aboriginal claims or had an impact on the environment. And there were attempts by organizations to question the legality of the administrative decision. And again, it goes back to that question of, does that organization have legal standing? So it is not often the case that there is a specific person who is aggrieved by an administrative decision. And that is why oftentimes you need to also address the question of legal standing. Would that be clear enough? Okay, we're good. They were mostly men. I'm not sure what that is about. Okay. So
Manjo, sorry, it's Monique. Just to clarify further your comments on standing and your answer to my question earlier. Mm-hmm. So I guess the qualifier for standing isn't necessarily that a decision has been made in all cases, but that even if a decision would be made, potentially, that the person would be affected. So in the case of the abortion pills, the organisation, there's no chance they would have been affected unless an individual, was affected. But in regards to, say, road users, if there was a decision made about speeding or speeding fines, but no one had been affected yet, they could still potentially have standing because in an event that they breach that law, they would be affected.
So in relation to, there are two questions, there are two legal issues there. One is the question of standing. The other actually is the question of remedy. So let's discuss legal standing first. So we need to go back to what legal standing really means. And legal standing, as we will recall, means that there is a specific identifying identifiable right or interest or legitimate expectation that is impacted by a decision, and that is specific to a potential applicant, as opposed to something that applies broadly to everyone else. Okay, so that is what legal standing is.
Yeah, sorry, I might have used a bad example there for the road users.
Okay.
Okay, never mind. I might be confusing it. Sorry.
So the point there is that on the one hand, we look at legal standing, whether a person's rights, interests, or... So remember, there's that other aspect about legitimate expectation. So it's not always a right. It could be a legitimate expectation. For example, there is a legitimate expectation that when a law is applied, it will be applied equally to all. So if I'm applying for a job, then I would assume that I would be treated equally as everybody else. And so if I don't get a job so even if I don't get the job, because the law wasn't properly applied, my legitimate expectation to be treated fairly under the law would have been breached. So there's the legal standing there. But the other question you raised, actually, Monique, was about, what if no decision has yet been made, but potentially a decision could be made? Is it possible to apply for judicial review? And that brings us to the question about declaration, which I don't want to go into yet, because as I pointed out, because we discussed it in week 11, declaration is a judicial review which would enable a person whose rights, interests, or legitimate expectations could potentially be affected by a decision to seek recourse before the courts and ask the court to make a declaration that the law is invalid. So in other words, if you know, for example, that the taxman is about to make a decision which would mean that your funds might be garnished by the Australian Taxation Office, you shouldn't have to wait for the ATO to actually garnish your funds in the bank. You should be in a position, if you know that that the administrative decision is invalid, you should be in a position to already go before the courts. And then we talk about, later on, we will have, when it comes to judicial remedies, we talk about declaration, we talk about injunctions as well. Okay, but I mean, we're moving too far ahead. Okay, can we proceed? We're good? Okay. Can I ask a volunteer to read the first discussion question for us? Volunteers? Just to read the question.
I'll read it, Manjo.
Thank you, Tita.
The Commonwealth Development Authority Act, Commonwealth, authorised the Commonwealth Development Authority, CDA, to compulsorily purchase or acquire any land necessary to meet the infrastructure needs for new roads and highways of the Commonwealth. At the CDA's executive meeting on 16th of May 2013, the CDA's executive officer proposed the purchase of a sizable property along Benwick Road that was close to an area where a multi-million-dollar commercial complex was being developed. He noted that Benwick Road property is likely to appreciate in value as a result of the commercial development going on in the area. The proposal was approved by the CDA Executive Committee. In June 2013, Greg Harrison received a letter from the CDA stating that we were commencing negotiations with him for the purchase and acquisition of his property along Benwick Road, as authorised by the Commonwealth Development Authority Act, Commonwealth. Greg does not wish to sell his property and has come to you as a solicitor for advice. He brought with him a copy of the 16th of May 2013 Executive Committee meeting of the CDA. Advise Greg whether there are strong legal grounds to oppose the CDA's offer to purchase.
Thank you, Peter. So what I'm going to do is to just direct your attention to two factual problems here. One is that if you notice, based on the factual scenario, the Act says that any compulsory purchase or acquisition of land must be for the purpose of meeting the infrastructure needs for new roads and highways of the Commonwealth. So we're clear about that. And yet you notice that as far as the decision of the Executive Committee was concerned, they wanted to do it because because they thought that they were gonna be they will make money from the appreciation of the property. So it's kind of speculative. They were engaging in because it was likely to appreciate in value because of the commercial development going on in the area. So on the one hand, the act is specific. If a land is going to be acquired compulsorily or purchased compulsorily, it must be to meet the infrastructure needs for new roads. And yet, when the executive committee made a decision, they made a decision to acquire a land, the land belonging to GRED, because they knew that the value of that land would appreciate when there would be a commercial development that would go on in the area. So are we clear? We're clear. I just wanted to direct your attention there. So what do you think? If you were the lawyer for Greg, probably, you could indicate in the chat box, or you could pick up the mic. What would your advice be? Are there strong legal grounds to oppose CDA's offer to purchase?
The decision was made for an unauthorized purchase, an unauthorized purpose.
Mm-hmm. Very good. So that's actually the correct answer, Peter. You're correct there. So that reminds us that if there is a statutory power, the power must be exercised according to the purpose of the statute. Because if the decision is based on an unauthorized purpose, because there might be an ulterior purpose according to Gay, or there might be an ulterior motive, as pointed out by Belinda, or from the viewpoint of from Monique, there appears to be an irrelevant consideration. So the consideration is irrelevant because it's about speculation and investment as opposed to the need for new roads. Then that will be a legal ground for judicial review, because in that case, there would be the main legal ground would be that the statutory power was not exercised according to the purpose of the statute, and that is a ground for judicial review under the ADJR Act. And the cases we need to examine would mainly be Municipal Council of Sydney versus Campbell, as well as Iron Brownells Limited versus Ironmongers Wages Board. Okay, so that when there is when an administrative decision is made that is not consistent with the statutory purpose, and especially if there is an ulterior motive for that, then the decision, the administrative decision, would be invalid. Okay, very good. So we could proceed. I'm just going to jump to another question, and I just kind of changed the facts here. So what has happened is that the facts are almost the same, except that this time I made it a point so that as far as the law is concerned, it now says that the compulsory purchase or acquisition of land can be based on, the need to meet infrastructure needs for new roads or for investment purposes. Okay? So the question then is, if, the same facts happened, but there is a change in the law, as we said, so that the decision to acquire the land was because of investment purposes, would there be a valid ground for judicial review?
Manjo, would it depend on which one of those provisions was the primary and which one was the subordinate?
Very good question. So let's look at that. Let's look at that, point raised by Leone. So let's assume that the law says that, because what we will often remember is that a law can have multiple purposes, right? And in fact, as I highlighted earlier, a law can have conflicting purposes. So Social Security, for example, on the one hand, wants to give benefits to people, but at the same time, the government wants to make sure that it's only giving money to the right persons. the persons in need. It also wants to look at efficiency. It wants to look at justice. And oftentimes, these values conflict with each other. So going back to the question of Leone, what if a statute has multiple purposes, as they often do? And let's assume that in this particular factual scenario that we have, it actually contains a provision where the decision maker has the absolute discretion to make a decision according to the statute. What happens then? And so in other words, let's assume, what I'm saying is, let's assume that the law says the primary purpose is this. This is a secondary purpose. So let's assume that, that's the way the law is written. So we know what the primary purpose is, but the law also states that this is also another purpose of the law. So maybe the primary purpose is to meet the infrastructure needs for land or for new roads. And as a secondary purpose, it is for investment. Now, let's assume that the decision maker made a decision to focus on investment as opposed to, making a decision because the land is needed to meet infrastructure needs. So I throw back the question, would that make a difference? Can the decision be challenged so that, it could be said that the decision is made for an unauthorized purpose?
So what you're saying is that the investment purpose is now the primary provision? Is that what you're...
It is now an authorized purpose.
Yes, okay. So then, yeah.
In other words, there are multiple authorized purposes. It's no longer just one. So that if the decision was made or the action was taken on the basis of any of those authorized purposes, then the administrative decision would have been authorized by any of those purposes.
In that case,
yes.
It doesn't go against the purpose.
You muted yourself, Peter.
Sorry. In that case, it doesn't go against the purpose of the Act. So it'd be... It's authorised to purchase the land for investment purposes, so it wouldn't be open for judicial review. It wouldn't be an invalid purpose or unauthorised purpose.
That's right. Now, but let me just go back to the first point that we have here. So we're going back to the first scenario. Let's assume that the law simply says that the purchase of land or acquisition of land compulsorily is really to meet the infrastructure needs for new roads and highways, okay? And let us assume that you are Greg, and Greg feels that it's really not necessary. So let me repeat. Greg could argue that the executive, so let's assume that there is no minutes of the meeting, because I think I said that there are minutes of the meeting. Let's assume that there are no minutes of the meeting. But Greg is making the point that that land that belongs to him is really not needed for new roads and highways. Are you clear about the scenario this time? So Greg is making the point that that land is not needed because there are so many other lands. Why his particular land? That is his point. And he's therefore suggesting that the reason why this authority seeks to acquire his land is because it is for investment purposes. He does not have any evidence. He suspects that it is for investment purposes. And he's arguing that actually the CDA should have purchased some other land, not his, because his land is unnecessary. The question is, if that were the factual scenario, would there be a legal ground for judicial review?
In the absence of any plans or proposals or future for any roads or highways, I would say yes. It is a grounds for it could be argued as a grounds for judicial review. Yes,
because it could be argued that it's not really needed. Okay, interesting point. What do the others think? What do the others think? So Peter is making the point. So for those who might be confused, we kind of changed the facts. We're just chasing the point here. That let's assume that there is no evidence that the decision was made by the CDA for the purpose of speculation. No evidence. Greg suspects that it is speculative. And Greg is making the argument that his land is not necessary for the infrastructure needs. My question was, or is, would there be a legal ground for judicial review? Peter says there is. What do the others think?
Well, unless there is any planning involved, how can it be proved that it is for anything other than that?
Go on. Is that you, Carl?
Yes, it is. I mean, unless there is any form of planning involved, of planning scheme or direction or policy that would be hand in hand with the purchase, what else would be the cause? Well, what else would be their ability to do that as well?
Very good. Now, but that touches the bigger question, okay? Why wouldn't the courts, for example, undertake judicial review if there is a claim that the decision was made for an unauthorized purpose? What would stop the courts from reviewing the decision on the basis of a suspicion that it was undertaken for an unauthorized purpose?
Well, I mean, there's still the onus of proof to the balance of probabilities that this is the case. It's still the onus of proof is still to show that this is the case. So if there is no planning purpose, if there is no other reason, if they are still operating within their means but purely on a speculative basis for him then to suffer because of that, would that not fulfill? I mean, he has to be able to exhibit evidence and come across with the argument to have them believe that this may well be the case. But I mean, the onus is upon him to come up with all the information.
Very good.
So, on the balance of probabilities.
Very good. So Carl raises a very important point here. He talks about evidence. He talks about balance of probabilities. And therefore, when we talk, if you notice, if we talk about evidence and we talk about balance of probabilities, we're looking at the facts, right? We're looking at an evaluation of the facts. In other words, we're looking at the merits of the case, correct? And again, we need to remember that judicial review is mainly for the purpose of reviewing the legality of an administrative decision, not the factual correctness of a decision. So therefore, if the allegation were to be that, it's unnecessary, and that seems to be a factual question, whether or not it's needed or not, it's actually a factual question, courts are unlikely to touch it because that will go into the merits of the decision. And that is why I highlighted earlier that although, when there are applications for judicial review, questioning whether or not a decision was made for an authorized purpose or whether or not relevant considerations that should have been considered were not considered, or that there were irrelevant considerations that were considered when they shouldn't have been, they actually, in a sense, touch upon facts in the case. But that's being done because that is allowed by the law. As far as the ADGR Act is concerned, as far as Westbury and reasonableness is concerned. But the courts have also has also warned us that the courts have to be very wary about undertaking a merits review. So in this scenario, in the new scenario we have, where questions about evidence and questions about balance of probabilities are being raised, which actually involve the merits or the factual correctness of a decision, we will say that it does not involve a legal question. And in that case, therefore, there are unlikely to be grounds for judicial review. Okay. So let's just bear that in mind. So it's a tricky case because, you know, once an application for judicial review is sought on the basis that a decision did not consider a factor that should have been considered, or considered a factor that shouldn't have been considered, the courts are then actually examining, you know, the factual scenario, and in a sense, they're almost close to examining the merits, undertaking a merits review. And courts are actually aware of this. They know this, that they're doing that. And so the High Court has issued guidelines that, you know, when these things happen, then judges have to be aware that they might be intruding into merits review. Okay, so what else? Let me just have a look. Okay, so let's continue. Thank you there, Carl. Thank you, Peter. Okay, can I have a volunteer to read this third question for us? And then after this, we just have one final question that hopefully will help elucidate the important principles for the quiz. Can I get a volunteer to read?
Yeah, I'm happy to read, Manjo.
Thank you, Grant. Go ahead, please.
Under the National Business Risk Assessment Agency Act 2012, the National Business Risk Assessment Agency, NBRA, was created to examine, review and assess business risks to Australia and provide policy recommendations in the area of business risks to the federal government. The Act also empowered the NBRA to review its statutory mandate, broaden the scope of its purpose, and make every regulation necessary or convenient to be prescribed for carrying out or giving effect to this Act. In May 2013, the NBRA Executive Board, concerned about human rights violations and security threats in Afghanistan, Iraq and Syria, passed the Restricted Commercial and Business Activities Regulations 2013, which imposed huge fines on any Australian business that conducted or engaged in any new business or commercial activity in any of those countries without its prior written authority. The Hotbed Startup Proprietary Limited sought approval from the NBRA to sell its products in Syria. When the NBRA refused to give its approval, the company challenged the agency's legal authority to pass the Restricted Commercial and Business Activities Regulations 2013. In its letter to the company, the NBRA pointed out that under the National Business Risk Assessment Agency Act, they had broad and unqualified powers to validly pass the contested regulations. Hotbed Startup has approached you as a solicitor for advice. Advise the company whether it has a legal ground to challenge the decision of the NBRA.
Thank you, Grant. So again, just to to highlight the facts, so we will be quicker. You will notice that the Act focuses on assessment of business risks to Australia. Just want to highlight that, and provide policy recommendations in the area of business risks to the federal government. At the same time, it also empowers the NBRA to review its statutory mandate, broaden the scope of its purpose, and so on. And we will notice that when the NBRA passed certain regulations, what they then did was to look at security risks. So they then focused on human rights violations and security threats. So it would appear that the regulations of the NBRA are not consistent with what is in the Act. Okay, but yet, the Act also provides that the NBRA has the power to review its statutory mandate, broaden the scope of its purpose, etc. So, given the scenario, if Hotbed has approached you, what legal advice would you give? What do you think? So from Ilonka, no grounds, international treaties. Okay, so for Ilonka, she's saying that the decision is valid and it's difficult to challenge it in an application for judicial review. Gay talks about the power being limited by an implied purpose. Oh, wait, have I gone quiet? Have I gone quiet? Have I muted myself? Or you can hear me?
No, you're there.
Oh, okay, because Grant says, has Manjo gone quiet? I thought I was speaking. Okay, thank you, Carl. Comments? Oh, just a little bit quieter. Oh, probably not.
You know, I had to change speakers. It was difficult to hear, but you were there.
Okay, it might have something to do with the internet speed, which can affect, you know, the voice quality. Okay, so what do you think? Is there a ground for judicial review or a legal ground to challenge the decision of the NBRA?
The purpose of the purpose of the Act,
Yes.
Manjo, would be to assess the provide policy recommendations in the area of business to the federal government.
Mm.
Therefore, its review and to broaden the scope of its purpose would be a secondary purpose of the Act, surely. So therefore,
right. So Peter, I think highlighted an important point, which I actually missed. My argument would have been that there's a legal ground to challenge the decision. I'll focus first on what Peter correctly pointed out, because I thoroughly missed that. As Peter pointed out, the Act actually says that the power of the NBRA involves examining, reviewing, and assessing business risks, or providing policy recommendation. Instead, what has happened is that the NBRA has passed regulations where they would then impose huge fines in those organizations that fail to comply with the regulations. Correct? That seems to be over and beyond what the statutory authority actually is. And for that reason, the regulation would be invalid, because it's going beyond the statutory purpose, or it's going beyond the statutory authorization. So that's one. The second point is, we will notice that the purpose of the Act is actually in relation to trying to minimize business risks to Australia, or to business risks to the federal government. And yet what has happened is that as far as the regulations of the NBRA is concerned, they were focusing on human rights violations and security threats. It might be possible to argue that security threats can pose business risk, possibly, but human rights violations, it's difficult to see a strong connection between human rights violations and business risks. So, on the grounds that, one, the regulations seem to go beyond that allowed by the Act, in the sense that the Act only gives the NBRA authority to examine, review, and assess, and yet here NBRA has began to impose fines, so that is beyond the scope of the power given by the Act. And two, the purpose of the Act was actually to minimize or assess business risks to Australia, and yet the regulations are putting in an irrelevant consideration or an irrelevant purpose or an unauthorized purpose, which is about human rights violations. And so on these grounds that, one, the regulations are asserting a power that is beyond that authorized by the Act, or two, the regulations are imposing fines on the basis of human rights violations which are for an improper or an unauthorized purpose, then there are legal grounds for hotbed to challenge the legality of the regulations and the administrative decision. Now, the key point that needs to be highlighted here, or that should be emphasized, is that when there is a subordinate legislation which refers to a legislation or a regulation or a bylaw or guidelines that are issued by the executive on the basis of a primary or a delegated legislation coming from the Commonwealth Parliament, if there is a conflict between the primary legislation, that is the statute passed by the Commonwealth Parliament, and the regulations issued by the executive, then the regulations, to the extent that they contradict or are inconsistent with the primary legislation, will be invalid. In other words, it will always be the primary legislation that will prevail in the event of an inconsistency. Okay, so where there is an inconsistency between a statute, meaning the primary legislation, and a subordinate legislation, in other words, a statute, regulation, or bylaw or guideline. Did I use statute? So if there is a inconsistency between a statute passed by the Commonwealth Parliament and a regulation, bylaw, or guidelines or policies issued by the executive, in case of an inconsistency, it will always be the primary legislation or the statute passed by the Commonwealth Parliament that will prevail. Are we clear about that? So we make that point on the basis of a further question I have, which is the final one. Hang on, this one. And because that point is relevant to the quiz. So before we end tonight's session, I guess, can we just go quickly through this particular scenario just to emphasize a key point? Can I ask somebody to just read this particular question for us?
I'll read.
Thank you, Leonie.
P, who had just completed her fourth form school year on the 26th of November 1976, visited the Commonwealth Employment Service, or CES, in order to ask about her entitlement to unemployment benefits. Under the Social Services Act 1947 Commonwealth, the Act, a person shall be qualified to receive an unemployment benefit when he satisfies the Director General, DG, that he has met certain conditions under Section 107, Paragraph C of the Act. Under the Act, a school leaver can be entitled to unemployment benefits from the time of completing fourth form school and up to the end of the long school vacation for as long as certain conditions under Section 107, Paragraph C of the Act were met. However, the DG issued a policy which effectively disqualified all school leavers from being eligible for unemployment benefit from the end of the school year up to the end of the long school vacation. Following the DG's policy, the CES informed P that she could not, as a school leaver, be considered for unemployment benefits under the Act until after the end of the long vacation. P has come to you, a solicitor, for legal advice. What advice would you give her?
What advice would you give her? What do you think?
Manjo, just a question. Has she actually made application and been denied, or is this just general information she's been given?
Oh, very good. I did put it there. Oh, so we will assume that she actually applied. So it says here, following the third paragraph, I may have failed to clarify that. So following the DG's policy, the CES informed P, who probably applied, that she could not, as a school leaver, be considered for unemployment benefits under the Act. So she did apply. And she was denied. Her application was denied because the policy of the Director General is not to give unemployment benefits to school leavers until after the end of the long school holiday or long school vacation. What advice would you give her?
I would say that the policy is inconsistent with the Act and therefore she has grounds for review because the decision was unlawful.
Correct. So as pointed out correctly by Rob, it sounds like Green versus Daniels. This is the case of Green versus Daniels, right? Which Grant also noted. So actually, this is an example of how you write a factual scenario. I wrote another factual scenario. I just rewrote it. So this is an example of a factual scenario. And then, you know, it allows you to look at a potential legal issue. So actually, all the factual problems that I write, these give you examples of how to write a factual scenario, right? So there are plenty of examples you can see. So this is the case of Green versus Daniels, where the High Court said that the policy of the Director General in disallowing school leavers from applying for unemployment benefit prior to the end of the long vacation was actually a policy that contradicted or was inconsistent with the Enabling Act and was therefore invalid.
Sorry, Manjo, I really hate to harp on about this standing issue, but for some reason, could I ask if you changed the factual scenario to that she was considering applying but hadn't yet applied, would she still have grounds for judicial review on the basis that it was inconsistent?
Yes.
Thanks.
So the reason for that is because, so again, we're talking of a judicial review remedy. The particular remedy involved would actually be declaration. So when there is a law that appears to be invalid, and the application of that law will lead to the rights or interests or legitimate expectations of a person to be impaired, then you can go to the court, even before a decision has been made to seek recourse. Only, but in that specific instance of declaration. Okay, questions, comments? We're good. So any questions before we end tonight's session? Anything else you'd like to clarify?
Hi, Manjo. Sorry, I just had a question about, I really feel like I've got an unfair advantage over my classmates now.
Because?
Because Danielson Green is my chosen case. So the exemplar is done and that we've just done the case. So should I choose another one?
No. No.
Okay.
Because your peers will have an unfair advantage again in some other topics.
Okay.
Case it then becomes relevant for that weekly topic. So that's good.
Okay.
Very good. Okay. Anything else?
I just have one question,
Yes.
Manjo.
Go ahead.
Just to clarify, there will be no tutorial next week?
No, definitely not. It's the Christmas holiday. No. There won't be a quiz either.
I thought as much, but I just wanted to be beyond certain. So thank you.
Yeah, there won't be any. I mean, I don't want to put you through the trouble of being at a tutorial. We won't have any. And neither will there be a quiz during the Christmas break. Okay, so if there are no further questions.
Nothing on the final paper yet, Manjo? Any dates?
No, I'm actually waiting for approval from the law discipline.
Yeah, thanks. It's all right.
So I can't release that until I get approval from them. I lodged it immediately after I heard from the Learning and Teaching Services, but I need to get approval from the law discipline before I can say when the release date will be. So that seems to be the requirement. Okay then. So thanks everyone again for joining tonight's session, and advance Merry Christmas. Let's pay attention to what makes us happy. This is the Christmas season, and let's laugh and enjoy the coming days. So see you after the Christmas holidays, and Merry Christmas. Good night. Bye.
Merry Christmas.
Merry Christmas.